Okay, welcome to chapter 10, where we talk about the specifics related to pretrial and trial procedures. We're going to talk today about what happens after an arrest has been made. We're talking about our bail systems, a little bit about bail reform. We're also going to talk about some of the pretrial services that go on dealing with defendants prior to a trial. We'll talk about the ways a defendant ends up in front of the court, either by indictment or through information processing. And then we'll begin the more formal processes within the court system. We'll talk about arraignment, plea bargaining, and plea negotiations. We'll talk about the legal rights of the accused, and then we'll kind of walk through the trial process at a high level. So, after a person has been arrested, officers have a couple of things that need to occur. One, they have to create a report that highlights what it is that happened and citing their reasonings or violations of law behind the arrest. And they have 48 hours in Kansas to submit what's called a probable cause affidavit to the court. Sometimes, and it will vary from one county to the next, that's simply directed to the county attorney who immediately chooses to file or not file a case. And in other cases, in most cases, when an arrest has been made, that probable cause affidavit is set before a magistrate. They find probable cause or not. And if they found probable cause for the arrest to be made, they'll do what's called a detention order and set a bond and usually give the county attorney a short period of time to decide whether or not to um, file a case or not. Probable cause affidavits must be filed with the court within that 48-hour time period. That's a constitutional limitation on how long we can detain someone without the court taking a look at the reasons behind that. When a complaint is filed by the prosecutor, that's the official charging document. That's the prosecutor stating that they've looked at the case, they've done a legal evaluation, and made a determination about what charges they feel are appropriate. And the next step at that point is either a first appearance, but most likely a combination of a first appearance and the arraignment. When the judge sets bail, it's important to understand that bail is a constitutional right that's shrouded under the Eighth Amendment. And though it's heavily criticized as being an overbearing or a preventative system, most defendants are released on bail pre-trial. There are several different types of bail that exist. There is an own recognizance bond in which someone simply signs a form promising to follow the rules put in front of them by the court, and they're allowed out without having to pay anything. There are cash bonds in which someone has to put money up on the arrestee's behalf, and they both agree to abide by rules and to secure an appearance for court. There are surety bonds in which cash isn't used, but owned property is, or someone is signing a legal document attesting to their net worth exceeding what the bond is. It gives the court financial recourse to go after someone if they ignore appearance orders and don't appear in front of the court. In Kansas, we have a system that's known as court bonds that still requires a cash payment. But instead of having to use a bail bondsman, the defendant themselves are allowed to put that money up. And in the event they're convicted, the money used for bail can be immediately applied to their fines. In other words, instead of using a bail bondsman where you may pay 10% of the bail and the bondsman gives the court a certificate that says they're vouching for the full amount of the bond, the money you pay to that bail bondsman is not retrievable. That's fees for services rendered, and they're not obligated to give that money back to a defendant, even if for some reason they were acquitted. With court bonds, if for some reason they were acquitted, that money is returned back to the defendant and they get to choose what it is that they want to do with that. I spoke a minute ago about bail reform. There's been a lot of conversation within the media nationwide about ways that we need to um, re- reanalyze or change the structure of bail. The heaviest criticisms are that bail amounts are unacceptable and racially biased. Um, Racial biases don't really apply to bail, even though they've tried. It would be more indicative of the arrests that are made instead of the bail levels that are applied. And even given how high people complain that bail amounts are, still 90% of um, arrestees post some kind of bond. Some states have no limits on how high bond amounts can be, and in other cases, structures are given, but mostly the legal requirement is a balancing act between the charge that has been filed before the court and the balance between how severe that crime is and public safety, meaning how likely is it that this person is to reoffend? Is the public in any danger by releasing this individual? And do we believe or not that they'll appear in court? Most of the reform arguments relate to OR bonds or increasing the level of crime in which an OR bond is applicable. In most cases, we see OR bonds applied in misdemeanor cases or small petty crimes. It's very rare to see an OR bond applied in a felony case, especially a person felony crime, because someone's been harmed in that process. A lot of times when someone has secured a bond and they're going to be released from jail before they go to court, they're assigned or sent to and through pretrial services. In Kansas, this is a dual role that court services officers who also supervise people on probation perform. Their job is to assist the court in verifying vital information, names, dates of birth, social security numbers, addresses, things of that nature, whether or not this person has a job, not just simply writing down what they're being told, but verifying that they are employed, and then any drug history or substance abuse history that may preclude themselves to being a high-risk person for being allowed out on bond. Risk assessments are typically determined, and that's a determination on a scale that gives that probation officer a measurement to determine how likely this person is to reoffend if they're released pre-trial, which convolutes the case and adds more cases to the court to deal with. Most people released through pretrial services are supervised. They're required to speak with or visit with a court services officer on a regular basis. They're usually drug tested. Their travel is restricted. They're not typically allowed to leave the state, where the state would have to file an extradition claim with another state and create more legal hurdles to bring them back should they do that. And then there's always abstinence requirements, meaning they have to agree not to use or possess alcohol or any unlawful drug, and then they're tested to make sure that that occurs. Formally having charges put before the court requires one of two processes, either an indictment, which is very rare in Kansas, or what's known as information processing. Indictments are functions of grand juries, and while we don't use them much in Kansas, the system still exists, and that's which juries are gathered and seated just like they would be for a trial, and the prosecutor presents the evidence in the case, and the grand jury's responsibility is to return either a true bill, meaning they agree or find that probable cause exists for a specific crime, or they return a no bill, meaning they don't believe the evidence is strong enough to indicate that charges are warranted. We see this predominantly in the federal court system. The federal court has a revolving grand jury in which, once that grand jury is impaneled, they will hear multiple cases and make that decision. It's also interesting to note that during the grand jury process, the defense is not typically present and or allowed to intervene during the grand jury process, meaning no counter evidence is presented at that point. Information processing refers to probable cause affidavits and to preliminary hearings. So when someone's been charged with a felony crime, that probable cause affidavit in the form of a complaint has already been presented to the judge, and then a hearing, an adversarial hearing in which both the prosecution and the defense are present, and the evidence is tested at that point. The judge is looking to determine that probable cause exists, that a crime was committed, that it was committed by that defendant, and that it was committed within the jurisdiction that the judge has authority to oversee. If the judge finds probable cause in the preliminary hearing, then that individual is bound over to the district court for trial and arraignment. Arraignment is the first formal process of the court. The court informs the defendant of what it is specifically they've been charged with. And not only do they cite the statute to them, but they also cite the potential penalties of being convicted of that crime. If a defendant is without counsel and is requesting counsel, the judge will appoint one at that time. They'll set bail at that time. And sometimes, if they've already got counsel, they'll accept a plea, meaning, how do you plead to this case? Guilty, not guilty, no contest, etc. In 95% of cases at arraignment, the defendant almost always pleads not guilty, and then a date is set for the preliminary hearing. Interestingly enough, in Kansas, from the time a defendant is arraigned, the court has 14 days to establish a preliminary hearing. That almost never happens on time, and it's up to the defense to request a continuance. But constitutionally, to prevent speedy trial issues and to prevent from detaining someone until they've been bound over, the court's obligated to set that hearing within 14 days. After a preliminary hearing or after probable cause has been established and it seems as though things are headed for trial, both the prosecution and the defense will engage typically into a plea bargaining scenario. Plea bargains are a concept that are not new to us, but are new to the legal system in that they're only about 150 years old. But the process benefits both prosecutors and the defense. It benefits the prosecutors because they're guaranteed a conviction of some kind at that point. It benefits the defense because they possess the ability to lower the severity of the crime that their client has been accused of. Plea bargaining requires the defendant to waive their constitutional rights. The defendant is the only person who can make that decision. Even if their counsel is advising them to do it, it's still their call. 90% of convictions today are settled through plea bargaining. It's very rare that cases actually go to a full trial. This is usually where most cases end, is at the plea bargain stage. In Kansas, negotiations must begin with the defense. In other words, a prosecutor cannot charge someone with murder and then after they've been arraigned say, well, we'll plead them to an aggravated assault if you'll take the deal. It's up to the defense to approach the prosecution to say, hey, let's think about this case and maybe restructure it a little bit. The pros and cons of plea negotiation, the benefits to it are that the costs to prosecute a case are reduced. It costs money to pay a defense lawyer their appointment fees. It costs money to bring a jury in and then panel them, and it costs money to put on a trial. It reduces court backlogs. If we can get rid of cases before they formally go to trial, it frees up a judge's calendar to deal with everything else that they would normally be dealing with. So that also makes it easier for prosecutors to keep their calendars clear and keep the processes moving. And then, of course, the defendant sees a lesser penalty than they ordinarily would have if they would have taken it all the way to trial. The negatives associated with plea negotiations is that it encourages defendants to give up their rights. Constitutional rights are sacred. They are a right that, as citizens, we all enjoy, and that no one can take away from us, no matter what has occurred. We're the only people who can choose to set aside our constitutional rights. But the plea negotiation process becomes a point of leverage that encourages those defendants to give those rights up. Another negatives are that dangerous offenders are not always appropriately sentenced or punished in a manner that is protective of public safety. That's still a balancing act that the court must still assess. And some plea negotiations, depending on the case, may mean that a dangerous offender is let out and back into the public long before they ever should be. And then false convictions are a greater probability. You might ask, how can a false conviction rate go higher through plea negotiations? Well, if you've been charged with a severe crime that may see you spending a considerable amount of your life in prison, even though you believe wholeheartedly you're innocent of it, and you've been offered the opportunity to cut that time imprisonment in half or by more than half, you may be convinced to go ahead and take a deal that you don't feel is right just to avoid spending a considerable amount of time incarcerated. I talked a minute ago about our constitutional rights. The court's first duty during the trial process is to ensure that every defendant in front of them has their constitutional rights protected. In other words, their job is to make sure that the government has not in any way overstepped those constitutional liberties that we're all afforded. And through that trial process, it's the responsibility of the courts to ensure that the judge assigned to the case is impartial, that they're not overly familiar with a specific defendant or would have a conflict of interest that would prevent them from ruling in an unbiased manner. They have the right to be competent at trial. Mental health is an issue in the criminal justice system. And if someone was of the mental capacity that they couldn't make appropriate decisions, they have the right to have that treated and have the right to be declared a competent person before that trial would ever occur. They have the right to confront their witnesses through their lawyer most of the time, but they have the right to test the evidence that's put in front of them. The compulsory process means that the defendant doesn't have to ask people to come testify on their behalf. They can demand that that occurs, and then the legal process for that is a subpoena. They have the right, just as does the government, to subpoena people into the courtroom and elicit testimony from them. They have the right to an impartial jury, and we'll talk about jury selection here in a minute. But that any jury, before it's ever seated, is tested for impartiality, tested for their knowledge of a specific case, tested for any biases that they may have, in order to ensure that that jury is going to consider the evidence that's presented to them and nothing else. Defendants have a right to a speedy trial. What timelines look like for what is actually a speedy trial will depend upon the type of case that is being brought and will depend upon the jurisdiction in which that's being heard. In many cases, we see with homicide trials 24 to 36 months before that trial ever occurs because the amount of evidence involved is so enormous and the number of pretrial motions are so long that it just takes the court that much time to work through that before they're ever ready to get to a fair and impartial trial. The government has to understand that it's always under a ticking clock once the case is filed to make sure that things move forward. So it's incumbent on the government to ensure that the trial happens within those pre-described timelines. For adults and adults only, we have a right to a public trial, meaning the doors can't be shut from the public and the trial cannot be held in secret. Even the jury has to deal with the exposure of the public with them. Now, while their identities may never be revealed to the media, people can certainly be in the courtroom. Trials are a public process for adult courts. Now, for juvenile adjudication hearings, that's something completely different. But in adult criminal court, the right to a public trial is always upheld. The right to be convicted by proof beyond a reasonable doubt is a legal standard. Law enforcement officers have to recognize that they must have probable cause to make an arrest. Probable cause is the legal standard to get that case to trial, but conviction at trial requires proof beyond a reasonable doubt. This can be tricky sometimes because jurors sometimes, and it's what we call the CSI effect, are looking for pieces of evidence that sometimes are not there or sometimes that are unnecessary, or they get themselves in a position to consider proof beyond all reasonable doubt, and that is not the legal standard. The legal standard is proof beyond a reasonable doubt, not all doubt. Sometimes that gets kind of hairy. Once we get to the actual trial process, there are several steps that must be followed and can't be walked away from. Arguably the most important is jury selection, or the process that's known as voir dire, in which a pool of registered voters is brought to the courthouse. They're seated X number at a time to impanel a jury of 12 plus one alternate in felony cases. These jury members are questioned in court, and what those attorneys are doing are looking to test for biases, test for more information, knowledge about a case than what a jury might have, a prospective juror might have previously revealed. They're looking to impanel the most impartial jury that they can. In reality, prosecutors are looking to impanel a jury that's more likely to convict than not, and defense attorneys are looking to impanel a jury that's more likely to acquit than not. So there's a balancing act that takes place. Each party is granted X number of challenges to a juror, whether they should be seated or not based on answers to questions. And they're also empowered with X number of challenges that they don't have to provide a reason for. Ultimately, once they've eliminated all of their what's called preemptory challenges, it's up to the judge to make a determination whether a bias exists or not, or whether someone should be seated or not. And that's called a challenge for cause. and the attorneys must argue why someone should not be seated. Once the jury's been selected, they're sworn in, they're given preliminary instructions related to the case, and then both parties are given the opportunity to provide opening statements. Those are usually summaries, not only of the case, but summaries of the arguments that they're going to make. The government, being the entity that brought the criminal case, is allowed to go first. They present their evidence. While their evidence involves witnesses providing testimony, the defense is allowed to cross-examine those witnesses, in other words, to test or try to impeach that testimony by attacking their credibility or their certainty or their specific knowledge related to the case. The defense's case is next. They're allowed to present their own witnesses as well, and the government is allowed to cross-examine each of those witnesses. It's up to the defense to determine how much effort they put into their side of the case. Closing arguments becomes next. Each party gets an opportunity to summarize what it is that they presented. So think of it as these attorneys get up and explain what they're going to tell the jury. Then they tell the jury, and then they explain to the jury what it is that they told them. That's pretty critical in cases that go more than one day. Because jurors have short memories and they've been presented with a lot of information over a very short period of time. And so a lot of times you will see prosecutors highlight specific facets of a case, and sometimes those nuggets are just enough for a juror to remember what it was that they were presented with before. When those closing arguments are done, jury instructions that have been presented to both the defense and the prosecution, and they've had an opportunity to argue those instructions before the judge, are completed, and the judge will read those instructions. Usually those incorporate things like, here's what you can consider, here's what you cannot consider, here's what the law says about a particular case, and here's what you must decide. And usually they're asking the jury to make a determination of fact and not to answer a legal question. The jury's then excused and allowed to deliberate in private, in which they come up with a decision. And there's usually three responses that jury will be back. They will either come back with a guilty verdict, they will come back with a not guilty verdict, or they will come back and explain that they don't have the ability to draw a conclusion or that they are a hung jury. In many cases, that will lead to a mistrial when that occurs. After the verdict has been rendered, and sentencing occurs typically in a separate hearing later, but then the judge will sentence based on the convictions that occurred. And then appeals are typically filed after a trial. Those appeals are not necessarily pointed at the jury, the decision made, but they're pointed at decisions that the judge had made related to what evidence to allow into the trial and what evidence to keep out, and arguing that it influenced the jury unfairly because of the decision that the judge had made. Trials are laborious, and it's why plea bargains are so popular, because there is a ton of effort, as you can see, required by both the defense and the prosecution. In fact, the last jury trial that I was involved in lasted 2 days. It was a simple case. It was simply a possession with intent to distribute case in which we had confiscated a large amount of contraband and had plenty of records to show that this guy was, in fact, not just a drug user, but a drug dealer. But the amount of evidence involved and the number of procedures involved was a 2-day jury trial. So you can see why plea bargaining becomes so enticing both to defense and prosecutions. Well, that pretty well covers Chapter 10, at least at a high level. Remember, you've got to be reading the chapter to understand fully what it is that's going on. I look forward to your discussion posts, and we'll talk again in Chapter 11.